This is a online mediation seminar, webinar about the trials, tribulations, positives, negatives, and the future of online mediations. This is being presented jointly and sponsored jointly by the Upchurch Watson White Max Mediation Group, of which Mr. White and I are members. He's a principal, I'm a member. And the University of Florida Levin College of Law Institute for Dispute Resolution. Welcome, and we thank you for attending. Terry, will you tell the audience a little bit about yourself?
Well, I just started mediating last week for the beginning of my 33rd year, of exclusively mediating. So kind of like the farmer's commercial, I've seen a lot of things. And what we try to do today is to give you some of the things that we're seeing and experiencing and needing to work with and around with this new process. So I'm not just here as another pretty face. So there you go.
And my name is John Marion, and I have been an active litigator in the state of Florida for 37 years.
Piker.
Most 10 or 15 years litigating all over the state of Florida for various clients, and enjoyed that process until it got to be so much stress that I wanted to change a little bit of change of pace. And so Terry and the other principals in the business were kind enough to give me a chance to mediate. And I've been doing that for about 8-9 months now. And it's extremely rewarding. It's a great opportunity for me, and I'm having a great time doing it. And incidentally, right when I started this new profession for me, COVID hit. And so I've learned an awful lot. I had some in-person mediations, and most of the mediations I've had, though, have been by way of this platform, Zoom or other webinar type platforms. And we're here to talk about that experience today.
And I think, as it indicates, you know, the genesis of the greater usage is the result of obviously this COVID circumstance, but it has and it really wasn't being used much before. We had a lot of people, can I attend by phone? And attending by phone really doesn't help as much as this format does. You have no ability to see people, get a sense of, you know, when someone's not comfortable or something's just gone awry. So this has now brought the visuals in and has brought us all together. So it was not used much in the past. It's now being used a lot, almost exclusively, and some carriers actually still have limitations on their people's abilities to travel. One wonders how long they're going to keep that in place so that they can keep their travel expense down. But that would be something a cynic might wonder.
Of course.
John?
So the customary orders of the circuit courts in Florida were to require attendance, and that's what Terry was touching on. The belief always has been that doing this in person is going to be the most productive method. And so most insurance professionals, and hopefully we have some of those on the webinar today, had to travel to every mediation and had to be there in person. And in order for that to change, COVID came around, and the Florida Supreme Court entered an order that allowed non-essential business to be done by these types of platforms. And so it took away that mandatory requirement that the circuit courts would impose. And that, you know, that was a big deal for many of the plaintiffs' lawyers. Particularly, they wanted the insurance representative in front of them. And like anything else, change is hard for most of us. Trying to learn new tricks is hard for a lot of us old dogs. So this pandemic has caused a lot of us to get out of our comfort zone. And the Supreme Court, by lifting the requirement of people being required to attend in person allowed us to explore this type of video conference software. And as the slide says, it was hatched because of this COVID experience, and now we have several options to include phone mediations. A lot of mediations are conducted by phone, but these that Terry and I are involved in are typically in person or this new video conference type platform, and it's been pretty successful. Terry?
Yeah, the only other thing I would say is it has allowed us to become creative, and creative in many senses. One of the senses is in particular with carriers, and it has not happened often, but it can happen and does happen occasionally. And that is because we've got the ability to go to a private room. If that adjuster wants to or needs to converse with a supervisor, that supervisor can come in, that they can tell me, Terry, look, I've been told from above it ain't gonna happen. Okay, fine, let's talk about above. And bring them in, come on, let's have a conversation and kind of move it around. So again, creativity, it gives you the option to get to another level without having to get somebody else on a plane. So it's a creative option that's there.
So when this all happened, thanks, Terry, when all this happened and COVID began, we had to get off of the old horse we rode and get out of our comfort zone and learn things. Many lawyers, believe it or not, didn't even utilize computers. And so for them to be a part of the new world of COVID, they had to buy computers. And nowadays, almost every computer that you buy has a camera. Little story about that. My computer has a camera in it, and I am purple when I use my computer camera. And apparently, because they have to include them in all the computers now, they buy the cheapest camera they can. And so
that's only if you buy the cheapest computer, John.
No, not really. Not really. They save money where they can. And so rather than look like a Smurf, I spent a little bit of money on an external camera. But that was I was using computers and thought the camera on mine would work fine, but it didn't. So there was a lot of purchasing going on, or a lot of anxiety going on around the use of these kinds of platforms, because frankly, we didn't really think it was a workable option. From a litigation standpoint, I can tell you that it was rare that I ever took a videotape deposition, or a video conference deposition rather, because I always felt like being in the presence of the person was better. I could read them better, I could understand them better, I could transfer documents back and forth or hand them documents easier and better. But necessity is the mother of invention, and this pandemic caused us to get out of our comfort zone and learn how to do those things electronically. And frankly, it can be done very well electronically. But we all had to learn. Everybody, even those that were really familiar with the technology, had to learn. So that was a big process. And Terry, tell the audience a little bit about what the challenges were for you as a principal, and John Upchurch and Larry Watson and Rod Max and others. You have a mediation firm that is statewide and into Alabama as well, 2 states. You have beautiful mediation conference centers, and you're paying,
which we pay rent, I might point out, just commenting.
Lots of money in rent.
They're also empty right now.
So all of that created challenges for you and for the firm, but those same challenges existed across the board for the lawyers and the insurance companies and other businesses as well. Tell us a little bit about how you handled that.
One of the things that I think the firm is known for is that, our staff is extraordinary, and our staff makes so much of what we do look easy. I can tell you it was with extraordinary trepidation that the staff looked at me, looked at my computer, and looked at the world of Zoom and said, this is never going to work. But fortunately, with a little patience and perseverance, it has worked. And, you know, so to me, the staff is important, and we make our staff available during mediations just in case we have a glitch. And there really are not many glitches, but it's just nice to be able to call out a name and get it fixed. So obviously our whole team, all of our mediators have spent a lot of time and have become very proficient at it. So, you know, it was just a change in the business model, and you know, but it's been working reasonably well.
It has. And so in the beginning, I had a trip planned with my wife and left in the end of February, and then COVID hit. I came back to this whole new world of COVID. And what happened is Terry and John Upchurch and Larry Watson and Rod Max got together and figured out a way to host all of the mediators and all of the staff in teaching seminars on how to use these platforms. They had used GoToMe as one of the web platforms in the past, and so they were most familiar with that, but learned, I think, through educating themselves that this Zoom platform, which I think is the preferred platform by most of the lawyers and the mediators, because of a unique feature that others will probably come up with, and that's called the break rooms. And that way you can move people into separate caucuses and you can join them electronically. And it's made for a very meaningful process, much like being in a mediation conference center. The only real difference being that you can't knock on a door and ask for permission to come in. So we exchange telephone numbers and text and ask for permission to come in the breakout room so we're not interrupting private conversations. But back to the training, we all were trained in a Zoom platform. We all learned together. There were some who understood the process much better than others and had dug much deeper into it, and they were able to help the others learn how to use this platform to our advantage. And over time, we who then learned it, the mediators and our staff, were able to teach a lot of the lawyers who would use our services how to use this platform. And I think now, Terry, at least my experience is, almost everyone has a pretty good handle on how to use the platforms.
Yeah, I think that's true, and I think that though there are differences still in people's technological abilities. John and I were talking earlier about signing mediated settlement agreements, and for me, less technically proficient, and slightly older than John. It's easier if someone just does an email. These are the settlement terms. They send it out. People print it. They sign it. They then scan it and then send the original to us, and they all have originals. That's my way of getting the signed agreement, because we still need that signed agreement. There are more sophisticated ways. Electronic signatures is one if everybody's on the same program. But John also has his own way of handling it, and you'll see that his may have a few more technical bells and whistles. But then again, this is the pad that everyone is probably familiar with my using during the course of mediations.
Yeah, everybody has a different way, and we struggled with that as mediators. The firm-wide, we struggled with a way to handle that, and decided that everybody's going to have to figure out their own way that they're comfortable with. And Terry's comfortable with his way. Sometimes, though, there are participants in the mediation that don't have access to a printer or a scanner, and so that creates a little bit of a complexity. And what I did is I looked into I researched apps that might be available to people who have smartphones, and most everyone these days has a smartphone. And one app that I found that's free that helps this process is called Adobe Fill, F-I-L-L, and Sign. And that app allows people to open up a settlement agreement on their phone and open it up and scroll down to where their signature is supposed to be, and they can actually sign it with their fingertip. And then they can reply all and send it back to everyone. So I have a form mediated settlement agreement that's typewritten. And as I'm in the mediation process and I hear terms that the litigants want in the ultimate settlement agreement, and you don't know if you have a settlement yet, but they'll say this offer is contingent upon the plaintiff satisfying all liens, subrogated interest, etc., holding us harmless, I want it to be confidential, that kind of stuff. And so I can put together a general mediated settlement agreement without the amount in it. And ultimately, if there is a settlement, I can put it up on the screen through a feature called screen share, and we'll scroll through it with the lawyers and the parties. We'll modify it as necessary. At the bottom of the document, it says that I haven't drafted this. It's been drafted by the parties. I've been the scrivener for it. And ultimately, it will be signed in counterparts. Once the terms are agreed upon, I save it as a Word document, then a PDF, and I circulate it to everybody and my case manager and tell everybody to please sign it. And if they have a computer, they can sign electronically through a complex, expensive professional Adobe app or some other program, then they can do it that way. But if they don't have that, they can do it on their phone. And when they reply all, it goes back to everybody. So everybody should have a copy, but it goes to my case manager, who then scans all of the entire document and all the signature pages, and then circulates it to everybody so they'll have a copy. But all of this has happened over time. This is not something that happened overnight. And these are things that we all struggle with daily, but we're all getting pretty proficient at this program. So some of the successes that we've had in this new world we're in have a lot to do with the programs that exist. And what we've found as a mediation group is that Zoom is probably the leader. WebEx is also a platform that is used. We have belief that they will come out with a break room possibility within the next month or so. And so they may rival Zoom in that regard. We'll just have to see. Terry, have you done any of them by phone?
There are certain carriers in particular, although they're not many, but they won't use Zoom. They won't, and part of that is born of the sort of the horror stories of various people getting into your Zoom, etc. Well, in large part, that was a result of putting out a blast email of some sort that identified where the meeting was, who was going to be in it, etc. And so somebody obviously hacks and decides to screen share some things that maybe had nothing to do with the case. So, that's something to be aware of, that there is more than one modality. However, given the manner by which we distribute the link and how people get in, that is not a problem. Now, it doesn't. If someone believes it's a problem, they believe it's a problem, and so you need to work around it. And sometimes you have to utilize multiple modalities, WebEx for somebody and Zoom for somebody else. But it does. We do have the security. We do have the issue. Another issue that was advanced was concern about recording. You can record with Zoom. That's true. You can. Actually, you can't. I can. John can, if we wanted to. But our setting, all of our settings for all of our firms are no recording. So the two complaints we've had, people can get in and recording, really they're within our control, and we've I think found the best ways to deal with them. But there are different platforms. So
Yeah, the Zoom, early on, there was a lot of trepidation about using Zoom because of the very things you're talking about. There was this concept called Zoom bombing and what have you. And I think the media started spreading that story without knowing much about the details. And Zoom immediately jumped on it, and their president and CEO circulated an email saying, look, this pandemic has created challenges for all of us in the video conferencing world. We hadn't expected the volume of people that we had using it and using it in the manner that it's being used. And what happened is people who would put on programs, let's say, that wanted a vast audience, would send out an invitation and ask people if you have some friends or whatever that you want to see this presentation, and they wanted that, they were marketing, then forward the link. And it got into the hands of people who thought it would be funny to do things like Zoom bombing, jump in and they put all sorts of crazy stuff on the screen. And so that created a big issue. And the insurance industry, I think, responded and said, we're not going to do it by Zoom because they don't have security settings. Those were corrected very quickly. And one of the ways was to password protect your Zoom invitation so that only those who had the password could enter, number one. And of course, that could be forwarded by somebody if they wanted to, but in the mediation world, who would? We don't want it forwarded. We don't allow it to be forwarded. It's not forwarded with our permission except to those who are supposed to participate because mediations are confidential. However, we have another protection that the Upchurch firm mandated to all of its mediators, and that is that we create a waiting room. And that waiting room is another level of protection so that no one can enter unless, for example, Terry, who's mediating a case, he sees somebody wind up in his waiting room. He gets a dialog box that says they're there. They may just be a phone number, but Terry has to let them in. So he goes to his waiting room and says, hello, who are you? And once he determines that it's a person who needs to be or warrants to be in the mediation, he can let them into the mediation process. So it's a very secure, in my opinion, method for mediating and keeping the confidentiality of the parties that are involved in the words that are spoken. That's been corrected, and I think most of the platforms now are pretty secure. They have passwords and waiting rooms.
So on our end, which is always kind of fun, is occasionally a parent will be using their child's computer, and so you'll see Bobby's Playroom or whatever, or you'll get code Superman or Super Lady, and so you kind of have to identify who are you, and why did you pick that moniker? It really doesn't belong. So
who are you?
So you get through a screening that way too.
We have the option too as mediators to change that name so we can identify who is who. And oftentimes when there's a lot of parties, it's necessary to change Batman to John Smith, so you know who you're communicating with.
You just don't tell Batman because Batman feels badly when he's taken away from being Batman. So it's just on our end.
And so you can tell that Terry likes a little bit of humor in the world and in the world of mediation. And one of his concerns, I think, about the mediation video conferencing is making the two-dimensional world more three-dimensional. And so Terry, tell us a little bit about that concern.
One of the things I give John a lot of credit for is that it has been different breaking into this type of a professional environment simply with a camera and a screen, as many people who are probably participating today, a lot of years of interpersonal interactions, handshakes, consoling, and a lot of different things take place, and they've created the relationships, which makes it easier for someone like me because there's history. But for John, he's got his history obviously with the people that he knows, but it's a slightly different animal. And so John's correct. I spend a good amount of time, and not time but energy, trying to establish that a personal connection, whether by how you look, what you pick up on, how you find something to joke about, whatever that may be, so that people feel as if they know you and you're paying attention, because you are. But you need to give some nonverbal cues that that's occurring. And so, whether it's how you move, how you smile, where you try to get some level of engagement, it's very important. Where we have seen some challenges is certain people, some think, are passive aggressive. How can you identify that person? Well, they're not. They're aggressive if they won't put on their microphone and they won't put on their camera. But they're just passive aggressive if they'll leave their microphone on but only make a black screen. And so, there comes times where it's important to, whether it's in a private room, if their concern is they don't want it to happen in a joint session, they don't want to be seen, okay, fine. But in that private room, it is important to establish a visual contact with that person. And again, you're trying to take a two-dimensional process and keep it three-dimensional, and still keep some humanity in it, even though the process has become more computerized. So those are, it is important. It's very important for me. I've had two very contentious cases, and we actually had a backup. Our backup was that we committed that we would do an in-person mediation in the event we were not successful. Happy to say we were successful, and we had some fun while we were doing it. We got to move things around, and it all worked out. So we haven't had to default to the actual mediation. So that's what I consider the importance of that three-dimensional aspect.
That's a good point. And I guess I'd say not only do I agree with that, I'm like most people, people person. I like to be around people. For whatever reason, when you're in somebody's presence and not in this little box, you just get a better feeling for them. And nonverbal cues are very important. And Terry, you always talk about that. And oftentimes, and some of our audience may not understand some of the terms we're using. So just to back up a moment, these breakout rooms, the mediation typically starts out as an open session, just like in a normal live mediation, where all the parties are together, but they're in their little boxes, and they get to hear the presentation of the mediator to tell a little bit about what the process is. Then the opening statement by the plaintiff, and if there's more than one defendant, by them. Plaintiff will do a rebuttal, and then Terry and I and the other mediators will create breakout rooms. And so just like in a mediation conference center, you would move certain parties to different conference rooms. We're able to move you into a certain conference room, if you will, called a breakout room, which we'll name, and we get you in those rooms. And once you're in those rooms, you're in a private conversation. And then when Terry and I want to enter, we'll send a text, ask for permission to come in, so you're not talking about private matters when we enter. And when we're in the room, we listen to everything you have to say. When we leave the room, we can't hear anything you're saying. So it's a confidential process, and it's much like you're in the conference center. Everything that you're doing in your private breakout room is private to you, unless you let somebody in. So this has been a process that we've all adapted to, and I think over time it's gonna continue. One of the things I was interested to hear, Terry, John Upchurch was with me yesterday, and he had explained to some of the parties in his presentation that the Upchurch firm, fortunately, has not only survived this process, but in the process has thrived with the Zoom mediations. They've been very successful. Is that your experience as well?
Yeah, we've the settlement rate is not lower, despite what people may be advancing. And now with the types of cases that oftentimes are handled, when we were in person in a complex case, it may not get done that day, but we've been able to follow through and get them done nonetheless. And there have been circumstances where I want to talk to 2 or 3 of the people that were involved before, and guess what? You just set up another little Zoom. You set it up for a 15-minute whatever. You got all the people back in play again. The dynamics come back to everybody, and then you can move that around. So yes, we do have the ability to subsequently get together. We do have the ability to segregate. That was once in a slightly impish mode, and someone was a little annoying. I don't know why, but you can send someone to timeout. You can send someone to a room all by themselves, and the only thing they can do is say help, and so then you can go back. But I don't encourage that. But it is a button that can be pushed if it needs to be. So
they can ask for help in the break rooms. Only when there's a break room set up do you have the option as a party in the break room to push a button called Ask for Help on your computer, and that will alert the mediator, no matter where he or she might be in the Zoom process, for example, that they need to be going to that room as soon as they're able to. So lots of ways to communicate. The platform is an excellent substitute for live mediations. And so let's talk a little bit about what we've learned about the process through this pandemic and using the video conferencing. Some of the things that we have learned is that lawyers like it. I would say many of the lawyers, but as a category of lawyers, a lot of the plaintiffs' lawyers, to my surprise, like the platform because it allows them to be productive during the day as they're mediating. Those of us who have mediated in a litigation world, which was my world until this last year, it's a full day of mediating. If it's a large case, it could be more than a day. And so you're taken away from your practice and doing what you need to do otherwise because you're in this mediation process that's very, very lengthy. Well, it's lengthy, but there are so many breaks throughout the day because you're waiting for the mediator to go to the other room and talk to the other party. And so there's plenty of time where you could be productive. And what they're finding, at least what they're telling me, is that this platform allows them to be much more efficient and productive throughout the day because they're able to work in the time frames that the mediator is not with them. Terry, what are you hearing?
Well, I think what you say is true. Obviously, in a more genteel way, oddity of oddities. Not every lawyer is in love with their client. Not every lawyer is in love with their adjuster, and so it does.
Vice versa.
Right, and it does create the ability to spend time separately and get back in. You can step out and come back in. So that's a more efficient use, and it's also if you want to build a relationship, you can spend more time with the adjuster or the person that you typically would have otherwise had out to dinner the night before, or you can spend a little more time with your client. But when the silence becomes a little conspicuous because you've been there a long time, you got someplace to go. And so I think that's a plus that's available.
Insurance professionals also, you get different reads from them depending upon where they live. That's what I've been finding. Insurance professionals in the wintertime that are up north enjoy the travel to Florida. It's a nice change of pace. And so they get away and they like it. In the live world, they get away and they enjoy being where they are for a day or two. It does interrupt their ability to work, though most of us can work remotely these days with our laptops. It's still, you're out of the office and away. Some don't like it at all to travel. They would prefer to be productive in their office and not have to travel. But as we said earlier, the orders of the circuit courts in Florida required professionals in the insurance industry to be present during the mediation. So they didn't have a choice. Well, now that that's been lifted and they're allowed to attend by Zoom, many of them prefer that. They prefer to have the ability to be productive throughout the day when they're not in the caucuses, and they get more work done. They find they're not wasting time. But there's always going to be a need for those people to be in the room when it's a large case or complex issues and what have you. And they'll make that decision to come even when the pandemic goes away. Are you hearing the same thing from insurance people, Terry?
Yeah, I think the question's going to be, I think, at the end of the day, when they look at their business models and they look at their productivity and they look at their expense columns and whatever, is it going to take an act of Congress to have a live mediation where people are still required to physically attend? And I hope it's not misused, but that's where I think if we can establish, again, that three-dimensional aspect of a relationship with whomever those individuals may be, it'll take care of itself. But I think that's just part of the flexibility that we can work with.
One of the things that I've found, Terry, in trying to build a new business for myself, I mean, I stopped litigating cases and became a mediator because I wanted to. I wanted to change my world somewhat, and I always thought I'd enjoy this, and I am immensely enjoying it. But in a different way than you did. When you started mediating, it was always in the live format. And so one thing that's been helpful, I think, to me in beginning to grow my practice is that I have a broader reach with Zoom. I can mediate for people in Jacksonville and in Tampa and in the Keys and across the state with ease and without expense to them for me to travel. And I know you do a lot of traveling, but it opened the world up for me to lawyers across the state giving me a shot, see if I'm any good. And I think it's been helpful for me. And from the lawyer's standpoint, it's also given them a broader pool of mediators to pick from, because usually lawyers will pick someone in their locale because they avoid the travel expenses, unless there's a particular mediator that they feel is going to be the most effective for their case. And in many cases, that's you, and they pay to have you travel to their venue. And when the world opens back up, that's going to happen again, and probably will happen for me because of Zoom and because of my opportunity to mediate for people across the state that would have never used me or given me that shot. So it's been an interesting mix of good and bad for me, this pandemic. And I think that that's true for a lot of mediators. What do you think?
Well, what's curious is I probably was flying someplace at least 2 or 3 times a week in the state of Florida, and I have not flown since March, and so that is a dramatic shift. Yes, there is an expense involved in travel, and what's curious about that is I'm seeing some cases that might not have been able to handle the travel and what all, but now we can do them because we can get them done by Zoom. You know, at the end of the day, there's really yes, there are different lawyers and different rates, etc. You know, when you divide things by X and you spread stuff out, there's a base that you're going to have to pay no matter what. So the question is it going to get done? Because if it's not going to get done, it doesn't matter if it was less expensive, you still didn't get it done. So, but yeah, I do think that the travel aspect, my car is happy, my dealership is not, because I'm not getting it maintained as often. But oh well.
Yeah, I think getting a case settled through mediation with the right mediator is a lot less expensive than litigating the case all the way through. And so it's a function of who's going to be able to do the best job for you, and really is that travel expense going to be anything significant when in the grand scheme of things. And I think the answer is that insurance professionals figure out who helps them get their cases resolved, and they're willing to pay, and plaintiffs' lawyers too, to have the right person engaged. So what does the future hold for this video conferencing mediation process? I'm guessing, and I'm just guessing, that it's here to stay, and that it could be that 50% of the mediations from this point forward are going to be in this platform. What are your thoughts, Terry?
I think that is, I think that that's very true, and it may even be more than 50%. You know, and the business implications, we see the same thing in the law firms that we're dealing with, and even certain of the corporate offices that we interact with, that we're doing them from people's homes. We're doing them from, you know, I'm in the car, and you know, where that's going to have so in response to your question, I think that yes, it's going to be at least 50%. But I do think that there'll still be a need in the exceptional cases. And the case can be exceptional because of money. It can be exceptional because of dynamics. It can be exceptional because of guilt. It can be exceptional for a whole host of reasons. And every once in a while, you know, at the end of a mediation, the oddity of oddities, you know, sometimes you might get a hug from somebody as a mediator, just because there's a level of relief. And sometimes it's the plaintiff, and sometimes it's the defendant. And so, you know, if it's a case that warrants that, it'll still be there. So that's what I think. I think it's going to be at least half, which, you know, impacts commercial space. It's a whole series of things that flow from that. So we've always prided ourselves on trying to have the, you know, the best possible facilities and you know, some above average amenities available, because just to make people more comfortable, they don't want to be there. So, you know, it's hard to get mad at somebody if they're feeding you. So, you know, it's but that's changing, and you know, it's part of what we need to adapt to. So.
But there's always going to be a need for the live in-person mediations, and there's going to be practitioners that just don't believe that this is the most effective way to mediate their cases. And so we're going to always have people who prefer the live mediations once this pandemic is over. And so it'll continue to exist. It just may be on a less frequent basis. There's some people that are just frankly unwilling to change, unwilling to learn the technology and keep up with the challenges that exist when they update software. There's some folks that just don't want to do it. They're the old dogs that don't want to learn new tricks, and some people just don't believe you can resolve it. There's
But in
all
those,
cases, but
in those new tricks too, to me, one of the things that is actually much more interactive is the screen sharing. The ability, sometimes you had somebody on the phone or whatever, well, they can't see the PowerPoint, they can't see this exhibit, they can't see that. Okay, well, that's gone. But not only that, when page 27 says it's all my fault of the deposition, and that's what gets flashed up there, and then page 30 of the deposition says, until I realized that the traffic light wasn't working, and then it was not any of my fault. You can have dueling screens, and those dueling screens can be extraordinarily convincing to each side. In particular, if in a case you see cherry picking going on either side of the table. And all you do is you pull up your screen share and say, not so fast, Kemosabe. Let's take a look at this one. How are you going to explain that? So I do think the screen share feature is a properly used. I don't think you have to, have the hour and a half necessarily. It depends on the case, but to be able to be targeted in your use of what you expect to be the evidence in the case. I had one the other day. The question was, well, that's not really what the jury instruction will say. Well, my response to that was, you know what? I think there's an answer. Would somebody please pull up the jury instruction? And they did. And so we got it out of the way. So wishful thinking was gone. And so those are the kinds of opportunities you've got. So big opportunities that I think we have is we've got the opportunity to bring in other players. If there's somebody over and above that needs to talk, the adjuster needs to get upstream, and they're in the same building, and they just fine. We can get there. So those are opportunities that we would not have otherwise have had. So just a couple of things that I think the process has been good for us, and I continue to have fun with it. So.
Yeah, I think we will. So we're not out of time yet, but I wanted to make sure that everybody gets this slide, and you can see the Florida Bar course number is 2005769N for CLE credits. There's 1 hour of general credit and half an hour of technology credits for attending this seminar. And the information is there on that screen. If you want to take a picture of it with your phone, you don't have to write anything down. That might be a good technological way to save time. We do have a number of questions that have been posed throughout the day and even prior to the webinar beginning. And so Terry and I think would like to take a few of those questions. I'll start by one question by David. Did Zoom allow for the setting up of a caucus room on the fly if the mediator, for example, if the mediator wants to talk separately with attorneys? And yes, the answer is the mediator can set up a separate kick-out rooms for anything, and can put 2 lawyers in the room. If the plaintiff's lawyer wants to talk to the defense lawyer personally and privately, we can do that. We can move people around into separate breakout rooms that we create. Terry, can you grab a question that you might want to answer?
Yeah, the same is true. There may be cases sometimes where you actually have experts that are participating in the mediation. And sometimes the issue is, well, Terry, if we could just get the experts together, fine, go knock yourself out, and you can deal with whatever you need to deal with. So reinforcing what John's saying is we can put anybody together anytime. And even if we're down to experts or whatever, or we're down to a problem in the drafting of a release or whatever, some language that's going to be in it, we can just pull the lawyers. We don't need everybody else involved. So some other questions that appear. One is, what if we have problems with IT issues? Was asked by another David, unless David has a lot of questions. The answer to is that we internally have the ability to generally cajole ourselves through things. The confidentiality that Sanders asked about, we've got the safeguards in play. We know how important it is, and it's what we have to protect. And so we're very much committed to it. Snag another question, John?
One of the other questions is a mediated settlement agreement electronically signed by Zoom attendees an enforceable settlement? It is. In this day now with the pandemic, all of these electronic signatures have been dealt with, and they are enforceable, just like any other electronic contract you might sign in these days. Many of us have had that experience, so that should be a non-issue.
Paul asked the question, is virtual mediation now more than ever just a temperature take for the defense and a cheap offer? Not if you engage the way that you can. You can engage. You can still, call a card, if that's just not, that's just not in play. You can get there. So I'm not seeing that in the cases that I'm handling. Maybe unfortunate in the sense of that people really want to give it a shot and see if they can get it done. If I'm working on a case, but I don't think they're temperature takers, and I think there are ways to take care of the temperature takers. And the way to do that is to ask them some very pointed questions, which either they can't answer, or they give an answer that doesn't make sense, which means it's not their answer, it's somebody else's answer. But it's going to be in the file. And, if things don't turn out well, at least it was asked. So I don't see it as a temperature taker. Any other one, John?
Yeah, William asks kind of an important question, I guess. A recording of the mediation session may compromise confidentiality. What is to prevent a party from recording the session? It's a felony. It is a felony to capture someone's voice without their permission in Florida. So if that should happen, the remedy is criminal prosecution. One of the reasons we've, as a firm, blocked off all recording possibilities in our platforms is that very reason. You can't record somebody's voice without their permission. Probably
another William also asks, are PowerPoints helpful at mediations in general and in online mediations in particular? The answer is it depends. If you find your PowerPoint has become tedious, I can assure you the other side has concluded that your PowerPoint has become tedious. So the word power is important, and so you use those points. But in this context, with screen sharing and PowerPoint, nobody can say they didn't see what you were talking about. And you can run, but you can't hide. If that's the testimony, it's the testimony, and you have to deal with it. So that's the medical record. That's the medical record. It says what it says. So I think they are helpful. A lot of people are verbal learners, take things in. If people, I'm sure, have noticed when I'm there, I'm constantly writing. I can't read what I write, but I'm constantly writing because that's what helps imprint it in my mind. Don't know if you got any other ones, John.
Yeah. David asked a question: do parties have to appear via video, or what do you do if someone does not or has IT issues? Well, they don't have to prove, unless the court says they have to be on video. They don't have to be on video. The Zoom invitation, for example, sends a phone number that you can call, and you can be in this platform even just by phone. And we always advise the participants what to do if they happen to drop off electronically on the video conference. They simply click on the Zoom link again and come back in, enter through the waiting room. And if we lose all contact abilities to reach them through the platform, I exchange in the beginning of the mediation process. I ask for phone numbers so I can reach out to them if they fall off the video conference. So we always get people back in.
One that's on here, I saw it earlier. I'm not putting my hand on it, but it dealt with preparation. Pre-mediation Zooms are also helpful. If you need to pull your adjuster in, or you need to pull in an attorney that you've associated on something, and you want to have a go around, it's just as easy as the phone, and it's a little more engaging. And again, if there's something you want me to look at, you can show it to me. So pre-mediation, we should also take advantage of the opportunity to get the connection, know who's who, and then utilize that to our best, to the process's best advantage.
And especially, Terry, just to follow up on that, if there's things that you wouldn't be able to discuss with the mediator when you're in the mediation process, maybe you're having difficulty with a client and you would like the mediator to voice opinions about damages, or the opinions about issues of liability or whatever, in those pre-mediation caucuses, either by Zoom or phone, you can let the mediator know that, and then he or she can be more effective in their job in assisting you to try to resolve your case. And pre-mediation reports and materials, I think, are extremely helpful to get us prepared so that we can best assist you in resolving your case. If we don't know your case until we get into the mediation process, it's hard for us to think on our feet all the time and come up with creative solutions for you, things that might impact the mediation process. So all of that ahead of time is very beneficial. At least I've found it that way. You tell.
Well, and it also impacts, at least for me, the preliminary remarks that I make. If I know that there are the following hotspots, it's causation, it's liability, it's whatever, I can hone my initial remarks to that and say, well, we're going to be talking about that one. This is probably a hotspot. All cases have 2 or 3 parts, but this is the one that looks like. Then everybody, whomever it is, they get it. Okay, this is what we're going to be focusing on. So it is important to get those items in advance, and whether it's done over the screen through this process, or whether it's done in writing, either is fine, but neither is not. It really is best to have some interaction before.
So thank you, Terry. I think we're out of time now. I'd like to personally thank you, Terry, for participating in this webinar. I think it's been a lot of fun for me. I hope it's been advantageous to the people who are participating as attendees. And on behalf of the Upchurch, Watson, White, and Max mediation firm, and on behalf of the University of Florida and its alternative resolution program, we thank you for attending. If you have questions you want answered, you can reach out to Terry or me in the email that is fashioned on this slide, and we'll try to answer them for you. It's been a real pleasure, and I think we'll probably have other Upchurch, Watson, White, and Max presentations in the future, so keep an eye out for those. Thanks again for attending.
And any questions, as John has said, feel free to shoot them out. For some of the younger attorneys are better at all of this than many of us are, and they may have some questions, or they may have some observations about stuff that we should or shouldn't be doing. And I encourage them to get in touch with us too. So appreciate it. Thank you very much.